The clerk, calling Civil Matter 19 to 1987, Christopher King vs. Facebook, Incorporated. Counsel, please come forward and state your appearances. M.R. King, good morning, Your Honor. Christopher King. The court, Mr. King. M.R. King, self-represented. M.R. Thole, good morning, Your Honor. Gavin Thole on behalf of Facebook. The court, okay. M.R. Malhotra, good morning, Your Honor. Pavan Malhotra on behalf of Facebook, as well. The court, welcome. All right. So Mr. King, what I want to focus on is the Communication Decency Act. M.R. King, of course. If I may briefly the court, no. M.R. King, just some housekeeping stuff, though. The court, let me tell you what I'm thinking, and then you can M.R. King, okay. The court, then you can go ahead M.R. King, sure. The court, and speak. So I'm really focused on section 230, c. 1. My understanding of your case is or your argument that you seek to hold Facebook liable for discrimination based on language, national origin, and political view. And that as a result, the CDA doesn't apply. And it seems to me that those claims would flow directly from the posts that Facebook removed, which makes it similar to all those other cases in this district, the Britain, Ibid, Lancaster, Carricksyially, Seeks for Justice. So if I followed, my question for you will be, if I followed the analysis in those cases, how would you distinguish yours from them? That's my central issue. Now, what kind of procedural issues are you interested in? M.R. King, there was a pending motion for in light of my overall argument, pardon me Your Honor, there was a pending motion for judicial notice of the USA Today story which focused on this very issue. And that matter was I agreed with counsel that it would be addressed, you know, at this stage, before the court. But that was a pending request. The court, so I read everything, but what I'm really interested in is the law here. And those cases would seem to, if I follow them, require dismissal of your case. So take on those cases, if you would. M.R. King, I shall. Just real briefly, I do want to pay homage to my mother, who is here with us, indicating. And also for Justice John Paul Stevens, just left us. I think they were both pioneers. I remember want to take that moment and do that. The court, okay. M.R. King, yes. Now, moving to your direct question, Your Honor, I have my contention is that this follows the Darna paragraph that I set forward, where the same course of conduct can provide rise for multiple claims. That's nothing new in the field of lawyering. And Darna said, you know, certain claims should be looked at as a contractual analysis. And that is what their own amicus counsel said. Not only did their own amicus counsel say that the law has been misconstrued for some time, I've compiled a list. I've read all the pleadings in all of these cases from all the counsel. None of them came with these issues of social concern. This case can't be developed in an envelope. The envelope is too broad for that. It didn't happen in a vacuum. And so we have before us the Darna case. We have their own amicus counsel, David Luckmeyer, in accord. We have Seattle attorney J.P. Dyer reached the same analysis in his law review. There is a Hastings law review which reached the same analysis, that the law is being misconstrued. And Hastings is right here. I could throw a rock and hit it. You know. And that's one of the best law schools in the country. We have the director of IBM saying that the law is not being applied properly, and needs to be filtered a different way, analyzed differently, to keep the context to keep ascribed with the enormous political and social realities that we have here. We have the NAACP boycott. Unprecedented. We have the 77 different media groups that came out against Facebook, and compelled them to do a civil rights audit, which still is incomplete with respect to discrimination on the platform a year later. So what we're looking at here, and there are also actions that Facebook took, in analyzing my requests for review, like, letting them sit for 2 weeks at a time. I think those things are also breaches of contract. Obviously I think I have showed the court recently where there's a white woman sitting there, and according to their own purported contract, in terms of service, you are allowed to self-referentially refer to yourself in a protected class that way. So why am I not allowed to say that I was being treated like a nigger, when I've got this white woman calling herself cracker trash? And that's okay. Now, common sense has been stood upon its head. And this act was created to protect the fledgling internet industry, 25 years ago. May I submit to the court, Your Honor, with all due respect, Mark Zuckerberg's worth $85 billion now. He's not part of any fledgling internet industry. He does not need protection from anybody. We need protection from Facebook. And that's what everyone is saying. Federal legislators. These legal commenters are saying that the statute is being misapplied, and that the same course of conduct may, under certain circumstances, give rise to a contractual or civil rights claim. The court, okay. So I think I do understand that argument. And I'm going to ask Facebook to respond to it in a section. But just so that I'm clear, what you're saying is that my esteemed colleagues in the cases that I just set out just have it wrong in the way that the CDA should be applied, because it's being applied far too broadly, particularly when claims of the nature that you're bringing are being brought. M.R. King, yes. I think, and that's exactly what Attorney Luckmeyer is saying. He's written briefs for Facebook. Okay, he's no foe of Facebook, he's that's what all these other scholars have said, including Hastings Law Review. And again, this does not arise. The thing was crafted with an eye toward protecting children from with an eye toward protecting children, and defamatory contact. I think I cited a case also recently, though, that I'll pull up for you in a moment, where it was a California case last year, where it addressed the fact that, hey, this is a defamatory issue. Okay. That's not at play in this issue, in this case. And I think they've gotten away with it for far too long. And everybody knows that we need to curtail the CDA, the DCA in this matter. And of course, my question and my point to you is that, you've got a unique opportunity, with everything that I've brought to this case, to start making a difference without engaging in unwarranted judicial activism. There's a certain thing of common sense. We can see that this is not what the act was designed to prevent, to address, rather. So at this point, we come back from Facebook's comment. In sum, if you look at a thing like their hate speech guidelines, I clearly have not violated them. Anyone can see that. But, if Facebook gets to put out this type of purported contract, and laugh at all of us while making billions off of our backs, what we have here is a completely illusory contract. And we have to go back to basic terms of statutory construction that you learned in law school. Congress did not intend for an absurd result to occur. But it's absurd what's been going on here. So Facebook basically can say nanny nanny boo boo to all of us, disregard whatever its policies allegedly are, and we have no recourse. The court, okay. I understand your argument. So how do you respond? M.R. Thole, thank you, Your Honor. A couple of points. First, with respect to the Communications Decency Act, we've cited a number of cases in our briefs, dismissing the claims, all of the claims, the theories of liability under which Mr. King has brought his complaint, under CDA immunity. The law, if you look at it, and if you look at the cases in this district, the court is to look at the crux of the allegations, not the name of the cause of action. And if you look at the crux of the allegations in this case on page 9 and 10 of Mr. King's complaint, all of the allegations specific to Mr. King are about posts he made on the Facebook platform. And that's really the complaint in this case. This case falls squarely within the type of cases that Your Honor listed in this district when these kinds of claims have been dismissed under the Communications Decency Act immunity, under 230, c. 1. squarely within Ninth Circuit precedent under the Barnes case. And Mr. King has acknowledged, in fact, that that's what the weight of authority says. With respect to the Darna case that Mr. King mentioned, that is somewhat of an outlier in this district. And it's an outlier with regards to Ninth Circuit precedent. We've cited other cases where claims for breach of contract and breach of good faith and fair dealing obligations have been dismissed under the Communications Decency Act immunity, where they seek similar types of relief for the factual allegations here. And if I may, Your Honor, I just would like to be heard on one final issue. The court, M.R. Thole, and that's our request that the complaint be dismissed with prejudice. And I just would like to state, Your Honor, Mr. King this is his third version of the complaint he's filed here in this case, in this district. He filed another case earlier in the state of Washington, alleging almost identical factual allegations. So he's had a number of opportunities to allege all the whole universe of facts that support or that he believes support his claims for relief. And so, if the court agrees that dismissal is warranted under the Communications Decency Act, leave to amend would be futile, Your Honor. The court, and so yeah, let's on that point, Mr. King, and then I'll give you a last word, M.R. King, The court, it seems to me that however your claims are alleged, they all arise from the posts. And what Facebook did with respect to the posts. And so I'm wondering whether you think there are facts that you could allege in addition to that. If I ended up sticking with the analysis of those other cases in the Northern District, whether there are any facts that you could allege that you think would make your claim survive. M.R. King, there are several holdings, Your Honor. And the first is the Seattle case never heard anything on the merits. That was strict. The court, well, just focus. I actually don't care about those cases. M.R. King, okay. The court, I only care about whether you think that you have additional things that you could allege that would avoid the sort of preclusive analyses of those cases that I mentioned, if that's where I end up going. That's what I'm wondering. M.R. King, two things to that, Your Honor, briefly. First of all, as the Hastings article by Joey O.U. suggests in 2013, the bad faith exception which generally goes to, c. 2, the overriding presence of clear-cut bad faith must overshadow all of it. Because, again, Congress does not intend for an absurd result. You know, for a global monolith to act in complete bad faith subverts the entire reason for the policy in the first place. Ab initio. They can't continue to do that, and laugh at the rest of us. That's part of it. But yes, I do believe that looking further into this, that I could narrow it a little bit. And I'm still not releasing any of my pending arguments, either. But I do think that this is a matter of social significance. The defendant tries to ignore it. But no, I just rattled off all these organizations. This is an unprecedented groundswell of support as for my position right now. The court, yeah. So I hear that argument, but I'm asking a much narrower question, which is, are there facts arising from the way that Facebook treated you that you can allege that are in addition to what you've already alleged, that would address the problem that I see with 230, c.1. M.R. King, well, what I can do, and I think this would be quite relevant, is to flesh out the point that Facebook's treatment of me is retaliatory breach, as opposed to the specific content in hand. Just the way that they process my claims and the way they are treating me is the court, arising from the things that you've already alleged. M.R. King, right. But there's a process at hand. And the way that they've gone about their processes, I can show that it is not truly something they're doing out of concern for what I posted. For example, get this. Here's the kicker. I have many blogs, but two blogs are at issue right here. I have one called, How to Sue Facebook, Blogspot, and Chris King's First Amendment page. Chris King's First Amendment page has been up for 18 years. Since my mom recommended I start blogging. Okay. Before it was even fashionable. I've been linking that to Facebook ever since I was a member of Facebook. You know, since '06, I think. Then, last year, when I filed the suit earlier this year, I created How to Sue Facebook. Everything that's in How to Sue Facebook is on Chris King's First Amendment page, indicating. But not everything here is here, of course, indicating. Okay. So after I called out the fact that Facebook was blocking both of these, indicating, Facebook comes up, and now they allow me to post Chris King's First Amendment page links, but not How to Sue Facebook links. So it's not the content. It's retaliation. The court, all right. So, thank you for your argument. I will look at this again when I get off the bench, and I will get an order out as soon as I can. M.R. King, thank you, Your Honor. The court, thank you very much. M.R. Thole, thank you. Proceedings concluded.